In common law terms, the curtilage is the land immediately surrounding the home, including any buildings or structures. In the context of the Fourth Amendment, where the curtilage ends, open fields begin, and open fields do not carry the same protections as the house and curtilage. For a more accurate depiction of curtilage, we're going to look at a Supreme Court case, United States versus Dunn. This is a decision from 1987, which provides the 4 criteria for establishing curtilage. So as we consider this criteria, just keep in mind this illustration. In the Dunn case, law enforcement used electronic beepers and aerial photography to track drug manufacturing supplies to Dunn's ranch. The ranch had a fence surrounding the perimeter, as well as several interior fences. Law enforcement officers entered the property without a warrant and crossed several fences to get near Dunn's barn. The barn was about 60 yards away from Dunn's house, and a fence separated the 2 buildings. Police smelled phenylacetic acid and heard a motor running in the barn. They approached the barn, but they didn't enter. The officers did shine a flashlight through netting above the door and observed what looked like a drug laboratory. Again, they didn't enter the barn. The officers made several similar visits, never entering, but looking into the barn, before obtaining a warrant to search the barn and Dunn's house. During the search, police seized chemicals and equipment used for drug making. At his trial, Dunn unsuccessfully moved to suppress evidence obtained during the search. A jury convicted him on federal drug charges. So the legal question in this case is whether law enforcement needed a search warrant to peer inside the barn that is located on a field on private property. Answering in the negative, the Supreme Court held that the area near the barn is not within the curtilage of the house. So essentially, if the barn is not part of the curtilage, it is not protected by the Fourth Amendment, and the officers did not need a warrant to be in the position they were in which they peered into the barn. If the barn was determined to be part of the curtilage, then despite the fact that the officers didn't enter the barn, they would have violated the Fourth Amendment by being within the curtilage, so anything they saw while violating the law would be inadmissible. Okay, so the Supreme Court said that the barn wasn't in the curtilage. They also identified 4 factors relied upon to determine if a claimed area is within the curtilage of the home. Number 1, the proximity of the area to the home. Number 2, whether the area is within an enclosure surrounding the home. Number 3, the nature and uses to which the area is put. And number 4, the steps taken by the resident to protect the area from observation. In the Dunn case, the barn was 60 yards away from the house, 50 yards away from the fence that surrounded the house. The barn did not lie within the fenced area surrounding the house. The officers had objective data that the barn was not used as part of Dunn's home. And finally, Dunn did little to nothing to protect the barn area from observation from those standing outside.